Ms. Lehman.
Chief Justice Marshall, Your Honors. I'm before this court on Commonwealth versus Clark. The three issues I would like to address, the first two issues dealing with the jury selection. Number one, the challenge of Juror 5-8, who stated that she believed African American people as a group were more likely to commit crimes due to their economic status. My client asked the court to dismiss this juror for cause. The judge declined. I believe this was error because this juror was biased against my client. My client is an indigent African American. He was sitting before that jury.
Were you out of peremptories?
At that point, I had one peremptory left.
Does that make a difference?
Yes. If the defendant is forced to use his last peremptory on a juror that should have been excused for cause, a juror that came up next was one who had a friend who died of a drug overdose, had another friend who was deeply involved with cocaine, and had a close friend who was a police officer. That's clearly the type of juror that would have been peremptorily challenged. That was noted on the record.
Did you end up using all your peremptories?
The last peremptory was expended on Juror 5-8, who said she believed African Americans were more likely to commit a crime, so that the next juror who had the friends who died of a drug overdose, who my client wanted to dismiss, he could not.
Oh, there actually was the next one?
Yes.
Yeah, okay.
So there were two jurors involved.
In this case, didn't the judge have further conversation with this juror and determined that she could be indifferent?
I don't believe it satisfied what this court has said in the Van Long case. She never took back her belief that African Americans were more likely to commit crimes due to economic circumstances. And
what was it that the judge said to her that the judge then led to the judge concluding that she was indifferent?
He said, "You think they are more likely as a group?" Yes. And with that belief, do you think you could be an impartial juror here? Yes, I do. Why is that? Because I think it would depend on the person's circumstances. Well, that's not enough. The person's circumstances, my client's there as an indigent African American, sitting. He's not some middle class, upper middle class person charged with a white collar crime who maybe would fit into her category of that's not an economic circumstance that she, would believe that you were more likely to commit a crime due to your race.
How did she know he was indigent?
Well, I would suggest that I don't think my client walked in there in a very nice suit or, looking the part of someone who is upper middle class. That's not on the record, but it's a drug case. It's a heroin distribution case. It's a crack cocaine distribution case. It's not money laundering or embezzlement or.
Defense lawyers don't put suits on their clients when they bring them to court.
They're not always available.
Well, put it this way: he doesn't. The fact that he had a well-cut suit with monogrammed cuffs and so on wouldn't necessarily show that he was rich. But the fact that, in fact, it's well known that most defense attorneys do try to quote dress up their clients. That if they haven't, it wouldn't be an unreasonable inference for somebody to say this is a poor black person.
I think due to the nature of the crime he was being charged with, and the case being tried, it's either an inference. It's improper to assume that he was someone who was wealthy or someone who was poor. I don't think he's the type of client. He's the type of client who fits into what she says is an African American who's more likely to commit a crime due to economic circumstances as a poor African American. Thus, I don't think her prejudice was gotten rid of by what the judge said to her. I don't think she was rehabilitated. I think she should have been excused for cause. The fact that my client had to use his last peremptory challenge on her and then was forced to accept an equally unacceptable juror next is the problem here. And this court has said if a juror is shown to entertain prejudice which would preclude his rendering a fair verdict, a gross injustice would be perpetrated in allowing that juror to sit. This is what this court said in Van Long. And also where there's an abundant latitude for selection of jurors, none should sit who are not entirely impartial. it would have been very easy to dismiss this juror for cause, give the defendant his one last challenge to exclude the next juror, and sit someone who was fair, who wasn't making these kind of statements.
Well, we have to find that it's an abuse of discretion by the judge.
Yes.
Right. And the follow-up questions that the judge asked or concerned whether she believed that she could be an impartial juror here, and she said yes. And why is that? Because I think it would depend on the person's circumstance.
Well, what does that mean? How is that enough? What is, he didn't go further and question
Well,
about...
he went further and asked if she would be more or less inclined to believe the testimony of a particular witness based on race or ethnic background. This seems to be a bias on economic grounds. Did you raise the challenge did you refer to the judge specifically the economic argument?
Well, I wasn't the trial attorney, so
the trial
attorney did not do that. That's a part of my second argument as well. I actually think it's very interesting that the Commonwealth used the essentially the economic argument in dismissing two jurors in argument 2, and then you have this juror who is prejudiced on, could be, say, economic grounds, but it's racial and economic grounds. The two are intertwined, and you can't take one from the other, especially in this case. And I would also suggest that the judge going into, would you be more or less inclined to believe the testimony of a particular witness, that's just in his line of questioning. That's the next step in what he would do in his voir dire is, would you believe a police officer over a civilian? That's not as a part of her rehabilitation. So I would suggest he's endorsed her belief that that it's okay to think African Americans are more likely to commit crimes due to economic circumstances, and then he's moving on to whether or not she would believe a civilian over a police officer. And then she's equally ambivalent there, not necessarily no. She doesn't say absolutely, I wouldn't credit a police officer more than another person in this case. She just says not necessarily. So I believe it's very problematic that this juror was not dismissed for cause, given her answers, and given that I believe the trial judge did abuse his discretion in not going further and not dismissing this juror, or at least not questioning her further in his attempt to rehabilitate her. And if I move on to argument 2, here we have the Commonwealth dismissing 2 African American jurors with the reason that they were, one of them was a young college student, the other one was a young, appearing to be unemployed person. She had not marked off that she had a job on her jury questionnaire. I believe, well, first of all, I don't think that this was a group-neutral explanation that should have been accepted by the court. The definition of neutral has been a reason which is not present in those non-minority panel members not struck by the Commonwealth. The Commonwealth cited to their the 19-year-old real estate agent, and since there's on the record it mentions there's one other African American, it's not the 19-year-old real estate agent. I suggest that that is that individual was a white male, 19-year-old. My problem with this is he's 19 years old, he's a real estate agent, he could have gotten the job the day before. The other woman could have lost her job the day before. She could have lost it the month before.
Let me ask you this, Ms. Raymond. The Commonwealth, in its brief, put out the colloquy with respect to the your first argument.
Yes.
I haven't looked at the record. When the Commonwealth said, I don't want this person on the jury because she's too young, or canceling the agenda, he or she is too young, did the judge follow up and question the Commonwealth?
As to the first juror, as to the second juror, the judge asked the Commonwealth for reasons why, and then the Commonwealth went into its explanation as to this. He didn't, as a general rule or as a general principle, he didn't accept or he routinely challenged jurors under a certain age who were either students or unemployed without regard to race. I believe this reason is improper under the statute, and just because he's...
So am I understanding you correctly that the prosecutor told the judge, in trial after trial after trial, I routinely challenge or exercise peremptory challenges because people are young, because they are students, because they are unemployed.
Yes, he said, and the Commonwealth has consistently done this with jurors regardless to race to the extent that they're under 20 unemployed. I find it as a prosecutor in my 18 years experience that they don't bring to bear the experience and sophistication that would be beneficial to a jury. And I mean, I think that's highly disturbing. You're cutting out a whole segment, two segments of society who do bring differing opinions as to older people.
How old
which is,
was this juror?
both of them, I believe, were 19. But one was a college student and the other one was unemployed and, you know, may have had a job before, may have been looking for a job. I mean, we don't know anything else because no further voir dire was done of those jurors to determine if indeed there was something wrong with them that they couldn't sit on a simple drug case. I mean, the problem is this is a simple drug case. All the jurors needed to decide was, were the police telling the truth? Did they see what they said they saw?
But it strikes me that if the prosecutor said, in this kind of case, my experience is that jurors under 20 really don't have enough life experience to sort of carefully consider the matter. That would be one thing. The specific nature of this case suggests to me that I don't want jurors that have virtually no life experience. But it is a little troubling. The Commonwealth goes on and says, well, I always exclude anyone who's under 20.
I found it highly troubling.
That to me makes this not sort of individually related to the facts or the specific issues in this case, but a general policy, which is a little more troubling. Now, was the argument made? What was the argument made below after this explanation was given? Because the judge goes on and makes extensive findings the next day. What was the argument below? That this was strictly race-based and therefore they should be excluded? I mean, the peremptories shouldn't be allowed for that reason?
You mean my argument before what did the defense attorney at the time?
Yes. What did the defense attorney say in response to the Commonwealth's explanation?
She took objection to it. I don't think she was required. I mean, her point was there's this 19-year-old real estate agent sitting on the jury, and I do think it's disingenuous to say a 19-year-old real estate agent has, you know, more life experience than a 19-year-old college student. I think it's.
The question is not
because you don't know anything more about it.
The question is not what you think. The question is, what did the judge then simply accept?
The judge did. The judge made findings that this reason satisfied.
At the time, at the hearing, did the judge say, I am satisfied?
Yes.
And did the defense attorney say, I object because, or just, I object, or did the defense attorney sit mute?
She objected because she said this was the second challenge to an African American, I believe. I think
that's okay.
She did not go further. She didn't bring up the economic issue. No, it appeared to me from the record she was going along with what the judge was saying, with the fact that the judge was challenging and forcing the Commonwealth to come up with an explanation. And then she said, please note my objection for the record, I believe, was.
We've said that age is not a protected group. Is that correct?
Yes.
There's a statute that says you can't discriminate on the basis of
yes,
age.
and I know that in Commonwealth versus Wood, this court noted that statute and didn't make, it was noted in a footnote, and nothing further was really said about it. But I believe you have a statute that specifically says you shall not exclude jurors due to economic status or occupation. And
that has nothing to do with jury selection in the courtroom. That has to do with calling jurors to come and serve.
I think, well, I believe this court could find that it does apply.
Well,
the other reason
it would be extraordinary for the legislature to say you have to make sure that people who are unemployed are not, for that reason, not permitted to sit on a jury, and then have the Commonwealth in a different form now as a prosecutor excluding people for precisely that reasons. Apparently, I haven't looked at the transcript. Apparently,
that is what that is my argument. My next point I wanted to bring is the fact that they're essentially going in through the back door, and then excluding these people, this segment of society that the statute specifically protects. And I don't think, well, I'll quit saying what might be. I submit the Commonwealth should not be allowed to do that. That's wrong to exclude two young students and young unemployed people.
What do we do about the fact that defense counsel didn't say to the judge, Judge, I have a statute here. This is my argument. Judge, I have a statute that says I cannot discriminate on the basis of age. Judge, you can't, there has been no tying of the exercise of this peremptory challenge to the facts of this case.
Well, I certainly brought it up in my appellate argument. She was in the middle of trial, in the middle of jury selection, didn't know about the statute.
Right, she didn't even raise this objection.
To her, it was it was a race issue.
Right, and the judge, sua sponte, when the Commonwealth challenged the second African American, said,
yes,
I would like an explanation. So she didn't even raise the objection. The trial attorney didn't even raise the objection to begin with.
Correct, but I don't think that's fatal to what this court can do. That's happened before. The judge is allowed sua sponte to bring it up. And
how many African Americans were seated on this jury?
One, but that also is not fatal. The court has said in Soares and other cases, just because there is one minority sitting on the jury, that's not fatal to the argument that what happened here was incorrect. And that's been in plenty of cases.
Well, I mean, the judge clearly found, and I think we have to give him the benefit here, that this challenge was not race-based. So it really turns on your second argument, which is whether or not there's another improper category used in this case, based on age or employment status.
It's both. It's the employment status, occupation, and age. And I would submit that this court should not allow the Commonwealth to continue doing this and cutting out these two segments of society. And if I can briefly address my third argument.
Briefly address, your time is up.
Okay. I'm sorry.
Ms. Lynch?
Good morning. May it please the Court. Bethany Lynch, Assistant District Attorney representing the Commonwealth. I will begin with the Juror 5-8 question, which is the juror who the judge declined to excuse for cause. In this case, the defense has a very heavy burden to prove that where the trial judge believed that the juror was impartial and allowed the juror to be seated.
What was the basis for the judges reaching that conclusion?
The basis was the juror said, what I would say unequivocally, that she could be impartial. She was asked whether she was aware of any feelings or bias towards African Americans, bias or prejudice. She responded, no, I do not have those feelings. Have your family member had any negative experiences?
How can you accept that when she has just said, do you believe that African American people as a group are more likely or less likely to commit crimes than other people, and I think because of their economic status, probably, right?
Yes.
Then she says, you think they are more likely as a group, meaning African American people as a group? Yes.
Yes. She then goes on to say, the judge goes on to ask if she can be impartial despite that opinion, and she says, yes, I do.
And what is
that
it?
She may be impartial.
And how does the judge explore that? Because it would depend on circumstances, right?
Yes, that's her. He says, and why is that? And she says it would depend on a circumstance. And I would submit that the judge, in holding that this juror was impartial, took her at her word that she could be impartial, and it depends on circumstance.
I understand he took her at her word, but he then asked whether the witness's race or ethnic background. Are you inclined to be? I don't think so. Right?
Yes.
What she has said is, she said, look, you've got a combination of black and poor. Black and poor is more likely, a black and poor person is more likely to commit a crime. The judge says, well, what about if it's just a black person? I think I can. I think.
That means that I think I can would be whether she'd be more inclined to accept the testimony or to believe the testimony. And she says she does not think that she will be. She did not, all she knew when she walked into this courtroom was that this was an African-American man on trial. She did not know his indigency status. She didn't know he was
How do we
poor.
know that? The judge never asked. The judge never asked about whether she had formed any particular views about this defendant.
Not
we know that?
particularly to this juror. I believe he did instruct that there was a presumption of innocence.
I
These were all in the
understand.
general
That's
questions.
completely irrelevant at this point. I'm asking on what basis the judge could conclude when somebody has said, I believe that poor black people are more inclined to commit a crime. And as far as I can see, there's no inquiry about poor black people. There is only an inquiry about black people, and she says, I don't think. Not, of course I wouldn't be inclined. I don't think I would be. And he says, I find this juror indifferent. Right after that.
That's true, Your Honor. And
So there's no inquiry about the prejudice that she says she harbors.
there's no further inquiry on the record, no. I would submit that what the judge is depending on is the fact that she is saying basically it's rather than the person's race, it's the person's economic circumstance that may or may not lead them to commit a
And he
crime.
never asks her about that.
Well, he asks her, no, he does not further explore that.
He doesn't.
No.
So what is the basis for the judge's finding that she is indifferent?
I would just submit, Your Honor, that he was there. He was the one who was actually interviewing her and got the sense of her demeanor. And the
That
answers...
is true in every case when we have a cold record.
Exactly. And in this case, I think that if you take her answers, even though he didn't do further explanation, I think exploration, her answers in and of themselves could lead the judge to believe, having been the judge standing there watching her answer these questions, that it was not a racially based
Isn't there a little
challenge.
bit of an intangible here that we as appellate judges can't deal with, and that is the judge saw this person, sized her up, sized her up, you know, and it's like, for what it's worth, it's like, well, I can tell this person is trying to be honest here. And we can never do that up here. The record may make it look the other way, but he's made a basic sort of character determination based on physical observations and intangibles that are almost exclusively within the province of a trial judge.
And I think that's true, Your Honor. I don't think it's possible to know exactly the judge's rationale, as he did not put it on the record. But I think in the moment, in the actual voir dire with this juror, he got a sense of her from these answers and found that she was impartial.
And found
would
it
not
basically
base it-
that she was being truthful.
Yes, Your Honor.
That she had this preconception, okay, but that she could deal with it and judge the case on the merits.
Yes, I believe that's what happened.
Ms. Lynch, what do you do with the fact that the defense counsel didn't object?
The defense counsel did not object.
I mean, the defense counsel, I take it, did object,
Well, she moved for cause.
but she didn't object to the fact that the judge hadn't pursued the inquiry.
No, she did, and she didn't ask for any further inquiry. She accepted the judge's ruling, and then, well, she listened to the judge's ruling, and then she moved to strike the juror for cause. He declined, having once again reiterated that he found her to be impartial.
What was the explanation for that she gave at that moment, at that instant, that she moved to excuse the person for cause?
She just said that she would like to excuse the juror for cause. She gave no further explanation. And the judge presumably assumed that it was because of her answer. He did comment on it and said, notwithstanding her statement that she had made earlier in the voir dire, he did not believe that that would disqualify her as a juror. The defense attorney moved to strike her for cause, and the judge declined to do so. The defense attorney then immediately exercised a peremptory challenge.
Let's talk a little bit about the challenges to people under 20 who are either students or unemployed as a systemic policy of the Commonwealth. At least that's how it was articulated. Isn't there something wrong with that?
Well, first of all, I would point out that this was not this was a racial challenge. The racial issue was the issue that
the judge raised.
The judge did, well,
Sua
yes, that the
sponte
judge
raised.
sua sponte raised, and put the burden on the Commonwealth to provide a group-neutral reason for the challenge, and the Commonwealth did provide that in stating that it was not because of race.
The group-neutral reasons, what kinds of groups are we talking about here? Only certain groups get group-neutral reasons?
I would suggest that it is only certain groups, and they are the groups that are enumerated in Article 1 and in SOARS, the groups including sex, race, color, creed, and national origin. Age has never been one of those protected groups, and as a peremptory challenge, they cannot be used to exclude members of these protected groups.
Why do you think we only look to those?
Because in those particular groups, there's an implication, or there's an implication that it is that the group holds a certain form of opinion.
I think that's if you are removing people from the jury, because that may be one reason why you don't want people, because they've been discriminated against. But we have a very powerful jurisprudence that says that you're entitled to a jury of your peers. Moreover, at least with respect to economic status, the legislature has said, oh, and by the way, what we mean by peers includes people who are not employed. And then the Commonwealth gets up and says, notwithstanding that the Commonwealth through the legislative branch has said the jury of one's peers shall include people who are unemployed, the Commonwealth in the executive branch gets up and says, I don't want people who are unemployed.
Well, it's not that the prosecutor didn't want people who were unemployed. In this case, it was a combination. It was the under 20, so it would only be from the years 18-year-olds to 20-year-olds who were either unemployed or had no life experience. They were students. And
would it be okay for a defendant to challenge everybody who was over 50 because they were jaded?
I don't see why not.
Yeah, they had too much life experience.
You don't see why not?
Why the defense attorney couldn't challenge people over 50?
Defense attorney saying, I routinely throw anybody who's over the age of 50, and oh, by the way, if they retired.
But don't we have cases saying that challenges on the basis of age are all right? I mean, we have several of them.
Yes, I believe that we do. We have Commonwealth versus Woods that says that age is not a protected class. In those cases,
was there a statement by either the defense counsel or the Commonwealth that as a routine matter they take everybody off? In other words, there can be a particular case, which was not articulated here as far as I can see, why age may in fact be relevant to the case. If you're in a protected class, race, gender, so on and so forth, you've got a bigger hurdle. But if you want to take somebody off and show in that case...
Well, in this case, they took off people, the prosecutor took off people who were under a certain age and had, the main point that the prosecutor was making wasn't age.
Did that, not because there was anything about this case, but because the prosecutor said, I always do this.
Right, because the prosecutor did not believe that a person of that age and inexperience had the maturity and responsibility to give the matter due consideration. And in his experience as a career prosecutor, he has found that to be the case.
But we have a statute that's... Oh, I'm sorry. Go ahead, Justice Harris.
I'm just curious. Don't you think it's a little inconsistent for the prosecutor to seat a 19-year-older
it is
and then remove the 19-year-older on the other side?
Well, and the explanation for that is that judge...
they're both the same age.
They're the same age, but one has a job and has a job outside of the home, is not a student, is a real estate agent, is working for a business.
Are you suggesting to me that there are no students in this Commonwealth who work?
No, I'm not saying that.
Well, so the fact that somebody is a student doesn't tell me anything about whether or not they work.
That's true. That's true.
In fact, in my experience, there's hardly a student in this Commonwealth who doesn't work.
That's true. I would submit that I don't want to get in trouble with students, but the jobs that students tend to do well during school that I did while I was in school don't
I
have the
don't
same
think we
level
can go there.
of responsibility.
Does the
I
record,
don't think we can go there.
does the record tell us anything about how long this 19-year-old real estate person had worked?
No.
How many cases they'd been involved in? How many sales?
No.
Anything along those lines?
It does not, and I believe the reason for that is that the focus of this voir dire for the most part, or this argument, was focusing on the racial aspect. They did talk about age, but they gave merely examples. In fact, I don't believe you can conclude that there was only one African American on the jury. There was at that point, at the point of this juror's challenge. I don't believe you can say, the record just isn't clear on that. It wasn't explored.
You really, I think your best argument is that there's two different considerations here. The statute that says everybody can serve, regardless of age and, all that kind of stuff, is designed to get everybody in the courthouse so that a jury can be picked. However, the actual picking of a jury is a very unique event that's entrusted to a large degree to the lawyers involved. They're allowed to shape their own jury. Now, we've said, and the U.S. and the Supreme Court has said, that in certain areas you can't get there, and that's race and so on, but age is not one of them. So if a prosecutor gets up or a defense lawyer and says, I don't want anybody under 20, fine. That's part of the unique psychology of picking a jury that's entrusted to lawyers that we haven't intruded on yet. That's got nothing to do with the policy behind the statute. Would that be a fair statement?
Yes, it would. I believe that they represent two completely
But if
different
that's
things.
used to exclude people of color, then it's not right, is it?
No, not if it's used strictly for that purpose.
But if we start saying that are we getting to a point where if we go this way, we should at some point say then we're not going to allow peremptories at all, because everyone challenges on the basis of what they believe, because you know so little about the person, that people of this ilk, and I am excluding any of the protected categories, race, sex, color, creed, etc., and national origin, beyond leaving those aside, prosecutors and defense attorneys alike, and in civil cases, plaintiff and defendant's lawyers, they say people of this economic ilk we don't want, we do want. We want people who are employed, we don't want people who are employed, depending on what you're representing or who you're representing at the time. And if we're going to start saying you can't do that, then it seems to me we should just get away from say no peremptories. Because how else, on what other basis would you exercise a peremptory? I don't like the color of their hair.
Well, and I think that eventually, if you were to go down this road, where age was, where you had to explain your age considerations, you have to explain, I don't like their employment status, I don't like this, you would get into the attorneys having to explain each and every peremptory challenge on the record.
No, we have said when you have challenges on particular categories, you have to have some explanation, some neutral explanation.
That's true, and this was not, neither of these characteristics of this juror were within those particular categories. They weren't within the protected categories, so up until now, the prosecutor hasn't had to explain them. The only reason he even made this explanation is it happened to be an African-American juror and it was the second one. So the judge, sua sponte, came forward and said, I would like an explanation, and the explanation was provided, and the trial judge was satisfied with the explanation and said that he didn't see any racially based reason, and that age, not being a protected class, cannot be used to disqualify the peremptory challenge.
Thank you, Ms.
Thank you very much.
Yeah, we got the issue.